Welcome back to Inspector Toolbelt Talk, everyone. Today we're going to be talking about a subject that I think a lot of us as home inspectors is one of the first things we quote unquote learn about the home inspection industry is the liability of it all. It seems like every new guy gets about 2 weeks into their courses or whatever, and then just all they talk about now is the liability. Am I going to get sued? I didn't know people get sued so much, yada, yada, yada. I say yada, yada, yada because number one, we're not as litigious of an industry as you might think we are. And even the parts of it that we are, home inspectors often don't get destroyed out of it. So keep that in mind. But as we go through this, home inspectors, we like to think that we create legal protection by being right. I hear that all the time. As a matter of fact, there's a home inspector I was talking to not long ago that put something into his report. And I'm like, man, does that seem like a good idea? And he says, listen, I could defend that in court all day long. But here's the problem. Most of us think that legal protection is about being right, and it's not. It's about being expensive to fight. So, for instance, if it costs somebody $15,000 to get through our agreement or report, they're not going to sue us for $10,000. So we can defend a point all day long. It's not about being right. It's about being expensive to get to. And we do that through creating layers. So that's what we're going to be talking about today is creating layers to get through us. Now, here's the legal disclaimer. I am not an attorney. I do not play one on television, and I'm not giving you legal advice. What I am giving you is some information that I learned myself from attorneys. We've hired attorneys, worked with attorneys, insurance companies, the whole nine yards. We've seen both ends of the whole thing happen. So we're just sharing with you what I learned. And always check with your attorney before implementing anything that's said on this show. So there's my legal disclaimer. Now for my personal disclaimer, because I know whenever I do a podcast like this, there's always somebody that says, Ian, you're just teaching home inspectors to avoid getting in trouble for something that they did wrong. What we're talking about here is unmeritorious claims. Joe, the inspection lawyer who we've had on this show, talks about how in his entire career of many decades, he's only ever seen a few meritorious claims against home inspectors. The vast majority are unmeritorious. They're not, in other words, they have no basis to them. So this isn't about hiding from responsibility. If you mess up, own it. This is about protecting yourself from weak, emotional, or opportunistic claims. Let me say that again. This isn't about hiding from responsibility. If you mess up, own it. This is about protecting yourself from weak, emotional, or opportunistic claims, which in my opinion and experience are 99.9% of the time what's happening. So, how do we not worry less about being right or what's defensible and think about things in the way of layers? So, what I learned from one attorney who was reviewing our contracts, he said that you want each layer to not be necessarily something that you're going to hang your hat on. Every layer of an agreement can be gotten through. It could be the most bulletproof agreement ever. An attorney can get through it. The point is, how much does it cost for the attorney to get through it? So attorneys, think of them as accountants. They're basically going to just do the quick math. So pretend Ian wants to sue you. You did a home inspection for me, and all of a sudden, hypothetically, I want to sue you. So I go to my attorney, and I say he showed up drunk, he stabbed a screwdriver through the wall, and he just used foul language in front of my children and missed a major defect of $25,000. I want to sue him for $25,000. That's my damages. First of all, the whole damages thing, that's a whole nother issue, which we could do a whole nother podcast on. But let's say I want to do that. The attorney's going to go, okay, that sounds like a terrible experience. Let's look at his agreement. Okay, I can see 5 layers here, and each layer is going to cost me $2,500 to argue through. So that's $25,000. You don't have a case. Or even if you did have a case, it's not worth it. This happened in real life. A guy called me and wanted to do an inspection for him. And he was actually became a real estate agent later on in life. But he said, hey, I don't want to hire anybody that has this, or this in their agreement. And I'm a talkative guy, so I'm talking with him, and he tells me, he goes, well, I tried to sue this guy, and each of those layers, the attorney told me, added up to more than what my claim would have been, or close enough that it wasn't worth it. So we want to build layers onto our protection to protect us from not meritorious claims, but unmeritorious ones. So here's the principles why, and we're going to bring out some quotes and some information from a document from the uscourts.gov website. So uscourts.gov. So for our Canadian listeners, I didn't pull anything up Canadian, I'm sorry. But it's from a study that they released on the cost of litigation. So a litigation cost survey. So it said average legal fees per case can exceed $2 million in larger matters. Even smaller civil cases can cost $5,000 to $36,000 in just attorney fees, and more if they proceed further. It says proceed further because there's lots of different steps in the whole process, but there's one, usually a demand letter for us. Two, pre-court stuff like depositions and, stuff like that. And then they decide is it going to go to court, mediation, arbitration, that kind of stuff. $5,000 to $36,000. That's why most claims against home inspectors end up going to small claims court, because it's just too expensive. The person can just show up on their own, no attorney fees, and there's usually a low level. Like in my area, you can only sue up to like $3,000 to $5,000 depending on the county that you're suing in. So that's not as big of a hit. If somebody's going to take us to a larger court setting with attorneys, just know that they're probably not going to sue us for that $20,000 roof defect, because any attorney is going to go, listen, best case scenario is going to cost us $5,000 to $10,000. Worst case scenario, $36,000. Your $20,000 roof, not worth the trouble. So that's one of the reasons why home inspectors, we don't get sued that often, at least not anymore, and at least not in larger courts. Usually it's going to be small claims court. And let's be honest, if we get sued for $3,000, does it hurt? Yeah, that stings. Is it going to put us out of business? Probably not. And then remember, that person still has to prove stuff. Like the court's usually going to have I'm going to call it a bias towards the consumer. But at the same time, they can't be like, my dishwasher broke a year and a half later. The court's going to be like, all right, that's not within reason. We're not going to do this. So the second point, a huge percentage of lawsuits are just transaction costs. So according to the same document, roughly 60% of U.S. tort costs are consumed in transaction costs. So that means it's not, a lot of outside cost. It's going to be lawyers, discovery, expert witnesses, depositions. So more than half the money in a lawsuit doesn't go to the person suing. It goes to the machine. So there's a lot of different ways that this happens. Some attorneys, if they have a really clear case, they'll take like a third of the winnings or a half of the winnings. But the lawsuits against home inspectors are not very clear cut. They're usually very murky and a lot of feelings one way or the other. And as long as we have good agreements and well-written reports, it's not so clear. So usually they're going to get paid by the hour in a lot of circumstances. So the person suing has to think, okay, what if I'm suing for $100,000? Very likely you're not going to get all $100,000. And if you're suing for $100,000, that's going to be a long case. You're going to have to miss work, stress, things like that. Is it worth maybe getting $50,000 out of that 100? And then most cases don't actually go to court. They'll usually end up getting, like, the attorney will be like, listen, you don't have a case halfway through. Now it cost you $20,000 and you didn't get anything. Or it goes to mediation and they give you half. Now it cost you $45,000 and you only got $5,000. So you can see the math here is not adding up for most people to sue a home inspector on an unmeritorious claim. Side point, this is also why most home inspectors get a demand letter instead of, a summons, a court summons. because most attorneys will go, all right, yeah, this isn't going to work out. Let's see if we can just send a letter. You pay me $500. I'll send a letter and see if he'll just give you $15,000 to settle it. And you know what? It works. Home inspectors will contact me and be like, Ian, I'm freaking out. And I'm not an attorney. I don't give them legal advice, but I'm just like, okay, if he had a claim, wouldn't he give you a court summons? Like, why is this attorney asking for $8,000 in a letter? I'm like, kind of take it into strides. Think about it from the math aspect of things. Discovery alone can bankrupt weak cases is point number 3. So according to this document, large cases can cost $600,000 to nearly $10 million for just discovery. So that means they are going to have to figure out a whole lot of stuff about what happened, emails, your documentation, subpoenaing things. There's a large portion of the case that just figuring out if the case is worth it is going to cost them money. A lot of people, when they're just angry at you and they bought like a turd of a house and they didn't listen to you, they didn't read the report, and they're just angry about the crack in the foundation that leaks a bit of water in that you told them about. Once they realize it's going to cost me $5-10 just to go through discovery to sue you, most people's anger just returns to leaving a bad review on Google. So the fourth point, litigation costs are rising. Somebody who wanted to sue you just a decade ago, it's going to cost them 57% more now to sue you. So that's a lot of money. So they have to find an attorney that's going to want to sue you for a very little bit of money typically, and in a very sketchy case. And they're going to have to now shell out more money to get stuff done, so their bottom line gets wrecked. And the person suing is going to be like, why is this so much more expensive than I expected? So suing isn't getting cheaper for people, it's getting more expensive. So what does this all mean? It means that is probably our greatest legal protection. The fact that suing us is so expensive. So again, we're not doing this to be icky and gross with people and schemy. If we miss something, we really mess up, own it. And I truly believe that most home inspectors own it. I talk to guys all the time. They're like, Ian, you know what? I didn't run that one sink. The one sink I didn't run, and it leaked all over the kitchen ceiling. I paid a guy and I fixed the ceiling. And then he turned it into marketing. He sent the agent a letter. He took pictures and, he turned it into marketing. But it's like, okay, cool. Own it. We're not going to hardline everybody and be like, go ahead and sue me. It's too expensive to. That's just being a terrible human being. We do what we can for people, and what we do for people will come back to us. But that doesn't mean when somebody is just emotionally or opportunistically coming after us. We actually had that happen not long ago. Somebody tried to come after us, and then even afterwards, they're like, I was just rolling the dice, basically seeing who I could get the money out of. And it's like, okay, it didn't go anywhere because we weren't backing down. We didn't do anything wrong. So how do we build layers? The first one is obviously our most common one is inspection agreements. So there's a few things that are in there and why they work. A limit of liability. So a limit of liability is typically going to be this inspection is limited to our liability is limited to the cost of the inspection. I have personally seen this hold up in court for other people. An engineering firm, and I've probably told this story on the podcast before, they did this terrible job and they actually ruined 3 things for this building owner in this giant building. So he went after them and he couldn't get money for the 2 other things, but the court ruled against the engineering firm for the one major structural beam. And I was talking to the engineers afterwards, or actually the building owner. And they said, and the building owner goes, cool, this cost me hundreds of thousands of dollars. That was the big item. Awesome. I'm going to be made whole. The engineering cost was about $1,000 or something along those lines. So because they had a limitation of liability, guess what the court ordered them to pay the building owner? That $1,000 for hundreds of thousands of dollars of damages. So they were still in the wrong, but that limitation of liability, their attorney should have caught, because now the building owner probably spent $60,000 to $100,000 in attorney fees getting to that, working it all the way through the court system just to be handed $1,000 check. So most attorneys will know that kind of stuff happens because, especially that one, that was a well-known case up here in the Northeast. So they're going to say, all right, there's a limitation of liability. First of all, that could be upheld. If it's upheld, no sense in suing the inspector. You just get your money back for the inspection, but you're going to spend 20 grand to get there. 20 grand to get $600. Not going to work. So most attorneys will just say things like, let's write them a demand letter. Let's see if we can squeeze it out of them. If that doesn't work, the statute of limitations. So most states and federally and stuff, there's statutes of limitations of when somebody can make a claim. You can't say, oh man, my dishwasher exploded in my face. I'm going to sue the manufacturer, but do it 20 years later. That's why there's statutes of limitations. So it's not like just vindictive. So most states will have like several years for it. Home inspectors, and this one I learned from an attorney that I used to teach a class with, and he talked about it in the class quite often. He goes, first of all, we as home inspectors sometimes make it too short. So we'll say 3 months statute of limitations, because you can make your own and the person can agree to it. It's like, oh, all right. The court tends to throw those out. He said, then you have it too long, like 3 years, and then people are just like, the court's like, hey, you agreed to it. Let's do the lawsuit. He told me and the class several times, 1 year is the sweet spot. Talk to your attorney about it. Every state is different, but he's like 1 year. He goes, that shows the court you're being magnanimous. Listen, even though my report, my agreement all say day of the inspection, I gave them a generous year of statute of limitations, because even though our reports and our agreements say day of inspection, that doesn't matter to courts when it comes to statute of limitations, although it is a layer that they have to fight through. So let's say that layer cost them 3 grand to get through. The next layer with our statute of limitations, another 6 grand to get through. Now they are, close to 10 grand before they can even start to work on the actual claim. So that's how the layers work. So it's not a matter of, is this bulletproof? No, it's a matter of, is it too expensive for people to come after you? This one has always been important to me. Requirements to notify you before repairs. So in our agreements, we say we have to have 2 weeks, and this was on attorney recommendation for us. Again, check with your own attorney in your own state, but agree to, within 2 weeks of discovery of the issue, to provide us with 1 written notice of the issue in what's that called? Certified mail. So we had to have it by certified mail. So there was a record of it. And not being vague. I forget how we have the language in it. Don't be vague. You have to tell us what's going on. And then we get to have full access to the home so that we or any contractors we need could come in and look at it and document. You have no idea how many times I have no idea, I guess, of how many times that might have saved me. Because we had one where the guy came and he's like, hey, a month ago we had to replace this dishwasher. I'm coming after you. First of all, it was a year and a half. Again, unmeritorious claims. It was a year and a half later, dishwasher broke, blah, blah, blah. And so I asked him, I'm like, you have my agreement there? He said, yeah, I do. I'm like, okay, where does it? I need written notice by certified mail. And you already fixed it. How do I know that there was an issue? He goes, I took pictures. I'm like, you sent me pictures of a dishwasher. I don't see any leak or anything. It's not being litigious or scummy. It's a reasonable request. And most courts, from what I understand, view that as a reasonable request. It's like going to the doctor and saying, I have a cold. I'm suing you because I caught a cold. But you go after you're all better and there's no trace of the cold in your body. Who the heck knows? What happened? I don't know. You just said you had a cold. Or it could not have been as bad. Or the contractor could have ripped the person off. Courts are going to be like, I guess. And any attorney's going to be like, listen, now you're in breach of contract. You said you would provide this. We could fight this, but now it's going to be more expensive. So the effects of these kinds of things in our reports and in our agreements is, 1, it forces legal interpretation, procedural compliance, and early attorney involvement, all of which create layers. So the attorney's going to go, we have to interpret this legally. I have to talk with the inspector's attorney, we have to study case law and interpret this. So the attorney has to get involved really early. So you're not blocking lawsuits, you're making them complicated. Remember, lawsuits can happen, but the more complicated you make it for them to do it for non-meritorious claims, the better. Now, as a side point, because I keep saying that, meritorious means it has merit to it. For a meritorious claim, you'd be surprised how quickly and cheaply these layers can go away, especially if it's, open court or something like that. $100,000 lawsuit, their house burned down because of something you have a picture of in your report, but you didn't say anything about. So you just didn't report on it, or you forgot, or you were drunk that day. Who knows? Those are meritorious claims. These layers don't matter. Do they have to get through them? Yeah, but a court's going to go, they lost their feet out in the snow in the middle of winter when their house caught on fire. They have medical bills and they lost their home. I don't care about your arbitration clause. I don't care about your limitation of liability. This is for unmeritorious claims where the court's like, all right, come on. So the other thing is arbitration clauses. Talk to your attorney about that. Most states, or a lot of states, don't allow, from what attorneys say, limitation of liability and an arbitration clause in it. New York State, from what I understand, does, which is my state. So give that some thought. But arbitration becomes expensive too. And the benefit of arbitration is it keeps it off court records. So clients will still look up and say, has this inspector ever been sued? If they find 3 lawsuits, you lose a lot of work, and especially if they go start talking about that in forums. You could have won every single case. They were all unmeritorious. But still, to an average consumer, why was he in court 3 times? Arbitration keeps that off court records. Number 2, scope limitation. This is easy for those of us in licensed states. Our states limit the scope. So there's termite damage in the rafters of an old house underneath insulation. Scope of standards is going to be, scope of limitations is going to be, I don't move insulation for most state standards. Okay, that's a layer. So now that attorney is suing you, going to have to fight through that. So what you make it very clear, you can put it in your agreements, you can put it in your reports, you can send it as an email attachment, pre-put it in your software with notifications. And then that way, when they understand your scope limitation, they can't go back and say, well, I thought he would have moved insulation. You're going to say, okay, in the agreement, in the report, and separately in an email, I sent you scope limitations, all specifically talking about this. Really makes it as airtight as possible. And standards of practice references. So it does 2 things. It reduces claim size and increases argument complexity. So the smaller the claim, the less worth it is to fight. So if they're going to claim damages for $100,000, all of a sudden that shrinks when there's scope limitation. Everything under the insulation isn't counted according to the attorney. So he's like, maybe we have a $10,000 case. So smaller the claim, the less worth it is to fight. 3, report language. Go back to last season. Listen to every podcast we did on report language. Get that tightened up. Clear disclaimers, maintenance versus defect differentiation. In other words, I hate to say this, narrative guys, technically there's a bit more liability in a narrative report than one that actually uses a combo like narratives and ratings. And then our dreaded language, recommend evaluation by a qualified specialist. That in of itself is important because it's deferred liability. So here's an example. Home inspector did an inspection. The buyers came and had the seller just fix it, didn't bring in a specialist, and ended up being more than what the inspector could even see. And the sellers obviously did a terrible job fixing it. I think, I don't remember this specifically, but I think the homeowner said he got a contractor, but he did a bulk of the work, something like that. So they wanted to come after the home inspector because it was more than they were expecting and the work was shoddy. The home inspector says, I said in my report, I recommend a specialist come. And in my disclaimers, it says, anytime we recommend that, you do it before closing. You bring your own specialist in. Did you do that? And they didn't. And that totally wiped out any merit to their case. So now, if they want to really push it and sue you for $500,000, which is a ridiculous case, they would need expert witnesses, interpretation battles. So now they're not just suing you, they're hiring experts to disagree with you. That gets expensive at $250 an hour before they even get into court. Process documentation, photos, notes, communication logs. I have how do I put this? I'll tell a story. There was a home inspector recently, great guy, and I was actually looking at his reports because I was helping with something with our app, and I'm like, oh, this guy's a good inspector. He's thorough and stuff like that. But he clears his inbox out all the time. I think they call them clean inboxers or something, where you don't save any emails and you don't save your messages, or you switch phone and all your text messages go away or something like that. Why? I have every email, every text message, every bit of paper from the past 20 years of inspecting. Storage is cheap. Store it on Dropbox if you have to. Pay Gmail a little extra for extra storage, although I don't think you're going to hit their limits. Save everything. That has saved me in the past. Some guy came and said, oh, you didn't do this and you didn't do that and you promised us this and that. And I had all the old emails. I'm like, here's where we discussed this. Here's your report, which I also know some home inspectors only keep the report for 3 or so years and then they discard them. I'm like, why? Storage is cheap. This guy was many, many years later, and it took the wind right out of his sail because I had everything. I didn't have to say, he said, she said. I just had it all. Keep everything. I don't care if it was the nicest client in the world. I know a guy that got sued 7 years later, home inspector did. He wasn't even the original owner of the company. He bought the company from another inspector. So he bought his liability 7 years later because that guy didn't have any layers, no layers whatsoever. He got sued for something. And unfortunately, one of the rare cases he lost. It was actually a meritorious claim, but against the guy who owned the company previously. The new guy did a fantastic job. So also a warning out there for anybody who is buying a company. You're also buying their liability. So follow-up and communication. Follow-up with our clients and agents is not just for marketing, although it's fantastic marketing. Take your software. If you use ITB, you can do this, whatever software you're using, and automate things. 2 weeks before the inspection, a day before the inspection, 3 days before the inspection, just well enough before the inspection that they have time to read the agreement. And then send a follow-up message. Do you have any questions? Then when they sign it, we have a record. Don't do this whole sign the agreement on site. Because there's something called duress, and we don't want to talk about that. We want, if they go to court, one of our best layers is, listen, if they didn't like the conditions of this agreement, they had 2 days to read it. They had a real estate attorney. They could have asked him. I sent them a message before. Hey, do you have any questions? They had opportunity. Then afterwards, they're like, well, I'm suing you 9 months later for this. It's like, well, if you had asked questions or read your report, because number one, I sent you text messages after, do you have any questions? 3 days afterwards, I sent a message saying, hey, I hope you enjoyed the report. Make sure you read it thoroughly. All of that leads to a high standard of care. So you present that in a court or to an attorney. I mean, this happened to a home inspector recently. I won't get into it, but they wanted to know when they got everything. And the inspector's like, listen, you got 5 notifications before, 20 afterwards, checking on you, asking thorough report, whole 9 yards. Even 9 months to a year later, another message saying, I hope you're enjoying your new home. If you ever need anything, let me know. That doesn't look like gross negligence, which is what they would try to prove against us. That looks like a high standard of care. That's an expensive layer to get through. So keep all of that stuff. You're forcing them to prove you were wrong, not just say it, which is hard to do when you have all that documentation. So you're closing off angles before they even exist. I love it. So the economics are really what protect us legally. So claim $10,000, but the legal cost to pursue it, $10,000, they're not going to sue us. So the rational decision from any rational attorney is going to be not sue. So layers. not a matter of if we are right, or I just put in there whatever I need to and I'm right and I could defend that in court all day long. Defending it in court is going to cost us just as much as it is the person trying to prove it. Do you want to spend 20 grand in court, or do you want to stop these things from happening with layers up ahead of time? So we want to make sure this isn't, I said this before, and I actually wrote it down to say it again. This isn't about hiding from responsibility. If you mess up, own it. This is about protecting yourself from weak, emotional, or opportunistic claims. We want to be ethical, professional, but defensible. So we may be a great inspector, but great inspectors don't just inspect homes. We manage risk, and the smartest ones don't rely on on one layer of protection. And I'm not saying I'm one of the smartest ones. I'm just saying the smartest ones that I know, they build 5, 6, 7 layers until the cost of getting through to them is higher than the claim itself. So hopefully this helps you. Hopefully this will help you look at your inspection reports, your agreements, your communication with your clients, and build as many layers as you can. Thank you for listening in to Inspector Toolbelt Talk, and we'll see you on the next episode.